Hello, everyone, and welcome to Uncivil Law. Today, we have a very interesting case on the Stand Your Ground law of Florida. And what makes it really interesting is that the person who was shot is a police officer. So, we're trying to determine whether or not Stand Your Ground applies when the person who was shot is law enforcement. This is from the Court of Appeals for the state of Florida, state court. This is the case of John Derrisit versus state of Florida. In this case, John Derrisit is being charged with shooting a police officer. He's claiming stand your ground applies. So we're going to read this case and figure out whether or not stand your ground applies when the person who is being shot is police. Let's read on. The parties are before this court for a second time on a petition filed by John Derrisit, seeking a writ to prohibit the continued prosecution of 3 charges pending against him, each for attempted, premeditated, first-degree murder of law enforcement officer while discharging a firearm regarding an incident that occurred in his home on the night of August 20th, 2015. So right away, we know that the stakes are pretty high. We're here on an appeal for the second time for a writ of prohibition. We want someone to be prohibited from doing something. What do we want to be prohibited? Continuing prosecution. What is the prosecution? 3 counts of attempted first-degree murder. So we would like to not be prosecuted for this attempted first-degree murder times 3. So John here is either going home or he's going to trial and facing what would presume are multiple life sentences. So a lot on the line. Let's read on. Palmetto asks, if an officer comes to you, how's that premeditated? I don't understand the question. Just because someone comes to someone else doesn't mean that the murder isn't premeditated. Let's assume that I mean, you can come up with any number of fact patterns, right? But I just because I walk up to you and you shoot me, without more, it's like it could be premeditated murder. I mean, the premeditation isn't very long, but if you decide, like, while I'm walking up to you, that, geez, I'd really like to commit a murder right now, so it's like, that doesn't quite work. As more fully discussed below, in our earlier decision, when this came to us the first time, we withheld the issuance of the writ of prohibition and relinquished jurisdiction back to the trial court, with directions the court resolve at a subsequent hearing 2 issues it specifically declined to address in its first order. Okay, so the trial court is asked in the first instance, please prevent this from going forward. And it says no. And the person says, well, here's some reasons. I'm like, I'm not going to get into those issues. So it goes to appeal. And the court says, nah, you really need to get into those issues. So it goes back for the trial court to do it. Fine. The first issue for consideration was whether the state proved, by clear and convincing evidence, that at the time Dorset used deadly force, he knew or reasonably should know the person against whom he was using such force were law enforcement officers. Second, we direct the court to determine whether the state has established by clear and convincing evidence that Dorset was using his dwelling or residence to further criminal activity. All right, so I need to explain a little bit about this clear and convincing evidence and why it's being used this way, right? So ultimately, to convict, we need to prove beyond a reasonable doubt, right? We all know this, right? But the issue is here we have potential immunity, the stand your ground law, right? So the stand your ground law applies unless it doesn't, right? So there's this default rule that says, well, it applies, but there's some exceptions, right? So the question is, to what degree do you have to prove the exceptions to deny the defense of stand your ground? Now, that doesn't mean that ultimately you won't be able to win at trial, right? Because the proof is different. But stand your ground provides a bar to prosecution, right? So the question is, what degree do we have to prove the exceptions to let this go to trial? And then ultimately trial, it may prove the exceptions still apply, right? So we might ultimately find you not guilty. So that's not the issue. The issue is, can you use this as a bar to prosecution, right? So we have some exceptions that apply, right? And we could have presumably any kind of standard we want, right? Now, a lot of courts in this kind of situation where there's like an affirmative defense like this, a lot of courts would go with preponderance of the evidence, more likely than not, right? So as long as it's more likely than not, then, we'll go one way or the other. So if the state could show, look, we have an exception that applies, we're 51% confident it applies, so we can go to trial. Again, the issue isn't conviction or not, because 51% is not going to get you to beyond reasonable doubt. The issue is, can we use it as a bar to the defense, right? But Florida has said, no, even though like in this kind of situation where it's an affirmative defense, even though like in parallel situations in other contexts, right, in other contexts in other states, in parallel contexts where you have these kind of affirmative defenses, even though like a lot of courts would go with preponderance of the evidence, 51%, it's not good enough for us. We need more. So you have to prove more than preponderance to show this case should be forward. Now, beyond a reasonable doubt doesn't really make sense because like that's the ultimate issue to be decided by the jury. So if you could show it beyond a reasonable doubt, you're just in a jury trial in the first place, right? Because that's like what you need for, right? So if you said, well, the standard is beyond a reasonable doubt, you're basically having a trial before the trial because you're trying to prove guilt beyond a reasonable doubt in order to get to the prosecution to prove guilt beyond a reasonable doubt. So basically, like you've like kind of like run into this logical circle. So that doesn't really make sense. But what we can do is clear and convincing evidence. It's more than preponderance, but not as much as beyond a reasonable doubt. How much is clear and convincing? There's not like a fixed percentage to this. So, as a rough number, 70% probably. It's about something like that. If you ask a dozen attorneys, come up with a dozen different answers. We all know preponderance is more likely than not. So we all know that's 50.1%. We all got that one down. But exactly what the percentage is on clear and convincing or beyond a reasonable doubt, you'll get different answers from different people. So what do I say it is? 70%. It's something in that ballpark. You might get someone saying as high as 85. It's a little bit high for my taste. But yeah, 70%. So it's like if we can show it 70%, we can go for it. The issue is only can we go to trial. So if we can show the exception applies with 70% confidence, we can go to trial. Ultimately, we'll have to prove it to beyond a reasonable doubt, which, again, depends on who you ask. 95, 98%. So there's like this 25% gap that, we still have to prove. But the only issue is can we go to trial or not? All right. So hopefully that was a good explanation of what's going on here. The parties thereafter appeared before the trial court on this remand issue. Do these two issues apply, right? Was it a police officer? Is this a known criminal hangout, right? Those are the two issues the trial court has to solve. And the parties agreed that the evidentiary hearing was not needed. They didn't need any more evidence. Instead, they stipulated the court could address these issues by relying on the voluminous record produced earlier from a 5-day hearing that addressed the standing ground motion. So both parties say, look, we don't need any more evidence, right? We already had like lots of evidence. Like trial court, we're not really sure why you didn't consider these issues, but as far as we're concerned, there's enough evidence on record. So both parties say there's enough evidence on record. We don't need more hearings. We just need like someone to come to the legal issues. The facts are what they are. We all know what there is. There's nothing left to do. So trial court, would you please like analyze the legal issue? That'd be great. All right, fire enough. Following additional briefing, because briefing would go to the legal issue, right? So we don't need an evidentiary hearing. We don't need more evidence, but we're trying to determine the law. And so, yeah, you would have briefing on that. So we're going to have briefing specifically on these two issues. That makes sense. So following this additional briefing, where both sides are arguing the law, the trial court entered an order finding the state had not established clear and convincing evidence that Dorset knew or should have known that when he fired his weapon, he was shooting at law enforcement. So you went on one ground. You didn't know or should have known that it was law enforcement. You were shooting at an intruder. The fact that it was a police was not known to you, so that exception does not apply. Fine. The court, however, did find the state established by clear and convincing evidence that Dorset was using his home to further criminal activity, thus denying the standard motion to dismiss. Okay. So Florida creates an exception. Like, you have a right to defend your home, but there's an exception to stand your ground. Like, you can't use your home for ongoing criminal activity. And so, like, if you're using it for ongoing criminal activity, then like the probability the police are going to come and bust on your door is pretty high. And so you can't use self-defense. And also not for least of reasons that there's like if you're using it as a drug den, for example, right? There's a pretty good probability that someone may come bust down your door who's not police, right? Who wants the drugs. So basically you've created a substantial risk of a threat to you that otherwise wouldn't exist because of illegal activity, right? It's not that you have a whole bunch of nice cars that you acquired or a whole bunch of nice TVs, right? That'd be all lawful, right? So the government is willing to protect you and allow you to protect yourself if you've made yourself an attractive target from legal activity. So if you have a whole bunch of jewelry and money and stuff in your house that it's lawful, the courts will protect you and allow you to protect yourself. However, if you've made yourself an attractive target because you have, mass piles of cocaine or something in your house, then, not so much. You made yourself an attractive target for people who might want to rob you. And, you don't have the right to defend your home because you've, through an unlawful manner, made yourself a target-rich environment. So it's like, we're not going to let you defend yourself in that circumstance. That isn't going to flow. So yeah, that kind of makes sense. So we found this guy is engaging in ongoing criminal activity. So it's like you have essentially invited, the people to bust down your door, and so you don't get to use self-defense. Okay, fair enough. For the following reasons, we grant the petition for the writ of prohibition, quash the trial court orders, and direct Dorset be discharged. So the Court of Appeals disagrees with the trial court on one element. It disagrees that his house was a den of ongoing iniquity. It says, no, you didn't prove it. So Dorset, we're going to enter a motion to dismiss. So your criminal nightmare is in fact over. You've gone from 3 counts of premeditated first-degree murder to 0. Go forth and sin no more, but your case is over. So let's discuss why. To provide some context to our analysis, always helpful, we set forth the following relevant facts from our earlier opinion discussing the deadly force. Fine. The petitioner, a 65-year-old retired General Motors auto worker, owns a home in Brevard County. Dorset's adult niece, Mary Ellis, lived with him at home. Dorset has no criminal record, worked part-time as a security guard at Port Carnival, and lawfully possesses a concealed weapons permit from Florida. He also apparently has taken a firearms training course, which is always a good thing. On August the 25th, 2015, at approximately 9:30 p.m., Ellis answered a knock on the front door. As she opened the door, a man reached inside the threshold of the house, grabbed her arm, and began pulling her outside the home and onto the covered front porch. Ellis struggled to resist the apparent abduction and screamed to her uncle that she needed help. At this point, 2 other men approached to physically assist the first man in pulling Ellis off the home and into her first yard. So there's a knock at the door. An arm reaches inside, tries to pull you outside, and says, "Please help me," as 2 other men now try to join this. So yeah, we can see this is a little terrifying, right? Dorset, having heard the screams for help, hurried from his bedroom to the front porch. He was armed. One of the 3 men saw Dorset rapidly advancing to the front door with a firearm and announced to 2 other men that a man with a gun was approaching. The 3 men abruptly released Ellis, pushing her towards the front door, and scattered out on the front lawn. Dorset immediately came out to his door and stood under the canopy part of the door. So 3 men are trying to apparently abduct this woman. The person is coming forward down with the gun, they say he's coming forward with the gun, and they scatter. Now, remind you, these are the findings of fact from the Court of Appeals, right? So this is the Court of Appeals saying this is what happened, right? So, ultimately, of course, there's not been a trial. We're down on preliminary hearings. But it's like, well, this is what we think happened. Okay, fair enough. At this point, Dorset raised his gun, called out to the men, and fired a warning shot up in the air, which may or may not be lawful, but, it's also not really a great idea because that bullet has to come down somewhere. But, yeah. There are 3 men now at diverse points on the front yard and likewise armed, immediately shot back at him. Dorset fired back. In total, more than 40 rounds were exchanged. Despite being fairly close to each other, because it was dark, none of the 4 men engaged in this incident had a clear view of the others. Dorset and his niece were both struck by gunfire, as one of the 3 men in Dorset's front yard was severely wounded in the abdomen. So we got 4 people engaging in gunfire. 40 shots are fired. Dorset is hit, and one of the guys is hit in the abdomen. So, we've got this exchange of gunfire in this Florida scene in Brevard County. It's Florida, I guess. So this is a thing that happened. It was only after the exchange of gunfire was concluded that Dorset was there shortly taken into custody that he learned that the 3 men who came to the home that night were, in fact, deputy sheriffs with Brevard County Sheriff's Office, Special Investigative Unit. I'm not sure what the word special in this description means, but yeah, they're special at least in one sense. Conducting a sting operation directed at Ellis, whom they believed to be performing acts of prostitution inside the home. They arrived at the home in unmarked vehicles and parked in the street away from the home. The deputy who first approached the home posed as a customer and was in plain clothes. He made arrangements with Ellis earlier that day to meet and engage in acts for money. This deputy was an individual whom Ellis first greeted at the door as her anticipated customer, and who entered the home by grabbing Ellis by the arm inside the threshold and pulling her out of the dwelling. The special investigative unit needs to learn a little bit more about how to engage a sting, right? Like you've knocked the door and they've answered the door. You want to prove that she's engaged in prostitution. You might want to go a little bit further down the line of actually having an exchange of money or something. We're not quite there to show the case yet. You acted a little bit prematurely. The other two deputies were not in uniform and were the individuals who assisted the first deputy in attempting to subdue the now screaming Ellis in order to make the warrantless late-night arrest for solicitation of prostitution. Not so good. No, you really can't do this. You need a little bit more to do this. If you believe that the exchange you had earlier in the day, where you apparently made arrangements, right? So apparently you made arrangements earlier in the day. So I would presume that would be enough in and of itself to get an arrest warrant, right? If you actually had a discussion, I'm going to come by this time of day and in exchange for $50, you're going to do whatever for me, and she says deal, right? I would assume that's enough to get an arrest warrant, but they want to conduct more. Okay, great. And now they're trying to conduct an arrest inside the home without an arrest warrant, without any immediate evidence of an ongoing felony. No, the home is special. You can't do this. If you want to go forward to actually show an actual exchange of money or something, then okay, but you're way premature on this one, yeah. In our earlier opinion, we concluded the trial court had erred in its conclusion that they're not entitled to a presumption of being in reasonable fear of imminent death or grievous bodily harm at the time of defense of the home. So, so the trial court initially punted the case on the issue that they didn't have a reasonable belief of imminent death or grievous bodily harm. So, self-defense law 101. To use deadly imminent force, you have to have an imminent threat of death or grievous bodily harm. Now, incidentally, what counts as grievous bodily harm? Well, the case law is fairly robust that rape qualifies. So you could view this as rape or attempted rape. So that might qualify as grievous bodily harm. Other things might qualify too, but the Court of Appeals said no, he had reason to believe that there was an imminent threat of death or grievous bodily harm. I don't know the case law well enough to say for sure, but I would assume that kidnapping would also qualify as grievous bodily harm. An attempted ongoing kidnapping seems like the kind of thing that probably falls into the category. So I don't have the case law in front of me, but I would assume that's the kind of thing that would apply for the same kind of reasons. So did he have belief that there was an ongoing threat of death or grievous bodily harm? Given what we know, seems like it, yes. So the Court of Appeals also said, yeah, seems like it. So yeah, he was entitled to this presumption. He did have a belief that there was a threat. Makes sense. The significance of the presumption, as described in the law, is that under the law, a person, such as Dorset, using force is justified in his conduct and is immune from criminal prosecution. Yeah. So if you have this presumption, you are immune. Stand your ground gives you an immunity from prosecution. However, the presumption of being in fear of imminent death or grievous bodily harm is not absolute. Significant here, subsection of the law of the applicable version of statute states that the presumption does not apply if the person who uses threats is engaged in criminal activity or is using the dwelling to occupy a furtherance of criminal activity. Again, if you're using it to store massive parts of cocaine, you're kind of inviting people to rob you. And you're doing an unlawful thing, so you don't get protection. Okay. The person against whom the defensive force is used is a law enforcement officer who attempts to enter the dwelling, residence, or vehicle in the performance of his duty, and the officer identified himself in accordance with applicable law, or the person using the force knew or reasonably should have known it was law enforcement. Yeah, given what we know, they're all in plain clothes. None of them announced themselves. No reason to believe they're law enforcement. The whole point was that it was a sting, which, if it's supposed to be a sting, you're not supposed to know it's law enforcement. So, yeah, there's no reason to know or should have known that's law enforcement. So, yeah, that definitely doesn't apply. But the whole, like, well, was this a place used for ongoing criminal activity? Well, that's going to be an issue, right? Because we have a suspect of ongoing prostitution. So maybe that exception qualifies. Well, that's what the trial court said. Let's see what the Court of Appeals wants to say. In the earlier denial order, the trial court specifically found it unnecessary to address these exemptions because they determined they are not entitled to the presumption. Yes, they are. After concluding the trial court was incorrect, and they were entitled to presumption, we relinquished jurisdiction as to whether or not these exceptions applied. So yes, the whole statute wouldn't apply if you weren't in fear. But you were in fear. But now some exceptions apply. Are any of those exceptions relevant? The court has now entered a second order, which is before this court. The trial court's finding, the state did not prove by clear and convincing evidence that Dorset knew or should have known he was discharging his firearm at law enforcement officers, is supported by the record. Yeah, it seems that way. They're all plain clothes. None of them announced themselves. Seems like it, yeah. They all came in unmarked cars, right? It was a sting operation, so it makes sense. However, as previously mentioned, the trial court did find the state had shown by clear and convincing evidence that at the time he was using his dwelling to further criminal activity. Thus, it did not alter its earlier ruling, resulting in a filing of this amended petition. So the trial court said initially, well, statute doesn't apply because you weren't in fear. The appellate court said, yes, he was. Now the trial court says, okay, but statute doesn't apply because this exception applies because his home was being used for ongoing criminal activity. So we're on issue number 2. Does the exception apply? Let's read on. In analyzing the order, we begin with the premise that the legislature has directed that a defendant who files a sufficient motion to dismiss is entitled to immunity unless the state clearly establishes he's not. So yes, this is a bar. You're entitled to immunity unless you're not. The presumption is you're not. And you have to overcome the presumption, not by mere preponderance, but by clear and convincing evidence, which again, depending on who you ask, 70%, 75%, someone might say 2/3, something in that ballpark is the standard we're trying to clear. So is the state shown it's at least 70% certain that the exception applies? Okay. Having previously determined that they filed a sufficient motion to dismiss, this positive question, the one that will dispose of the issue before us, or whether the factual foundings in his order, as discussed below, were clearly and convincingly proven. Did the state actually make clear and convincing proof? And so, what are the facts that support its conclusion that he was using the dwelling for criminal activity? Okay, did the trial court screw it up? Well, we know what the facts are, right? The facts have been well established. So really the issue, did the trial court screw up the legal conclusion? That's the issue we're trying to reach right now. We accept the preliminary factual findings in its order that Dorset knew his niece had been working as a prostitute and that she had committed acts of prostitution in her room at his house, as there's some evidence to support this finding. So, this 65-year-old retired General Motors worker was apparently aware that his niece was engaged in prostitution and was doing so inside his home. I don't know what that says about Florida family values, but apparently that's a thing that happened. Okay. From these facts, the trial court wrote in its order that logically, if the defendant allowed illegal activity to take place in his home was being used to further that illegal activity. Not a wholly unreasonable conclusion, right? If you knowingly allow illegal activity, the home is being used to further that activity, particularly since it's prostitution. The illegal activity is actually occurring inside the home. So trial court's conclusion sort of makes sense. In this conclusion of law, that is from the facts, we review de novo, right? So the ultimate legal conclusion is de novo, right? The facts are the facts. The legal conclusion is de novo. So it is a fact. It is a fact that this 65-year-old worker from GM who is retired is in fact knowingly allowing his niece to use his home for ongoing prostitution. Okay, that is a thing that is occurring in this home in Brevard County, Florida. What is the legal significance of that? That is the question. Let's read on. The law does not define the term to further criminal activity. Fair enough. I think it's, not something that particularly needs to be defined, but if it did define it, it would help us, but it doesn't define it. Not that it seems like the kind of thing that you need to define, but someone has to do it. Let's do it court. Accepting that the niece's acts of prostitution constitute criminal activity, which, they do. The next step in our analysis is defining the meaning of furthering. This we refer to the dictionary. So we're getting on a fairly technical legal point, as you sometimes do, right? So the issue is whether or not we are furthering the activity. Whether or not the defendant is furthering the activity by knowingly allowing his niece to use his home to engage in prostitution. Okay, is that furthering the criminal conduct? All right. The term further, as used by some dictionary, apparently the shorter Oxford English Dictionary is the one we're using right now. Fine. The term further is defined as to help, assist, promote, favor. Applying its definition to the evidence presented at the stand your ground evidentiary hearing leads us to conclude the trial court's finding that Dorset's knowledge that his niece had committed acts of prostitution in her room at his home, without more, does not rise to the level of Dorset using his residence to further criminal activity. That's wonderful, man. So, as a general proposition, the court's about to say this in about 5 seconds, but yeah, as a general proposition, mere knowledge is not enough, right? As a general proposition, mere knowledge is not enough. So, like, if I know that you're committing crimes, I'm not an accessory, I'm not a conspirator, I'm nothing, right? My mere knowledge that you're committing crimes is nothing. If I come upon you as you're committing an illegal act and I stand there and watch, and then I leave, I'm not guilty of anything, regardless of what you did, right? I don't have to act or intervene, absent some sort of affirmative duty, right? So absent some sort of affirmative duty, I don't have an obligation to act. So if I'm walking down the street and I see crime happening, I'm like, okay, that's interesting. Even if I stand there and watch the whole time or video it or whatever, maybe I blog about it, real-time blog the crime as it's happening. I'm not responsible for anything. So okay, so his mere knowledge without more is not furthering the crime in his own home. Okay, I understand the rationale of the court. I understand the distinction they're trying to make. I think it's legally correct. I just think it's funny. So I'm going to note the humor involved in this because I think it's hilarious and move on. The evidence presented at the stand your ground hearing showed that the niece has a long history of drug addiction and that, as a favor to his sister, Dorset allowed him to move into the home. Law enforcement testimony at the hearing indicates that they did not consider Dorset to be involved at all with the niece's prostitution activity, and they had no plans to arrest him as part of the sting. So, he's not a madam. What is the correct term for a male madam? Would it be pimp? Is that the same thing as a madam? Is that the same thing or is that a different thing? Is the correct term for a male madam pimp or is it different? Leave a comment in your description below arguing about the relative merits of what the male equivalent to a madam is in this context. I'm not quite sure, but so they're not saying he's that. Okay, he just happens to own the house. He's not a madam. Okay, fine. The state did not present evidence that Dorset participated in any fashion in arranging for the clients or customers. Yes, he's a hands-off property owner. Fair enough. Nor is there evidence Dorset provided his niece with physical protection during the engagements. So he wasn't standing security. Or they financially benefited from the niece prostitution. Apparently he's staying there as a favor, so presumably he's not even getting rent. So that's okay. Accordingly, because the trial court erred in determining Dorset's awareness of his niece's random acts of prostitution committed in her room, equated to him using his home to further criminal activity, we conclude that Dorset used defensive force as permitted under the statute, and the state failed to overcome immunity from criminal prostitution protection under the statute with clear and convincing evidence. Therefore, we grant the amended petition for writ of prohibition, quashing the orders to deny motion to dismiss, and remand the trial court to discharge Dorset and discharge the criminal prosecution. Super exciting, yeah. So that is the end of the criminal case of John Dorsett versus State of Florida. Unless the State of Florida wants to appeal to the Supreme Court of Florida. And if they do, I definitely want a piece of those oral arguments because that's going to be fun. But that appears to be the end of the case of John Dorsett versus the State of Florida. In this case, we learn that John Dorsett, 65-year-old retired auto worker, has a niece who's engaging in prostitution in his home. But John isn't responsible for any of that because he's not involved with any of that stuff. She does what she does on her side of the house. I do what I do on my side of the house. So, and it's my house. So I'm not furthering the house for the purposes of criminal prosecution. I know I have to wonder, and I mean, logically the answer would have to be yes, but I have to wonder if it's the same outcome if like one of your tenants, because she's effectively a tenant, even though she's not paying anything, right? If one of your tenants in your home is like using the room for drug dealing, does the logic still apply? I mean, presumably it would have to, right? I mean, there's nothing like logically different about drug dealing versus criminal prosecution or prostitution. So like logically it would have to apply one to the other. So maybe this is an exception that will be used by criminals in the future. Maybe instead of using their own home for their criminal deeds, they will rent a room from someone else and hope that someone else may use self-defense to save them. And that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.